Today on Diagnosing Health Care, we are going to be discussing the recent actions taken by the Trump administration that are impacting federally funded research at AMCs, hospitals, universities, and other institutions who engage in federally funded research. We are going to be talking about how the executive actions may impact existing or future grants of the government, and also how federal agencies have implemented these actions. And we'll discuss the various related legal challenges. We will conclude by discussing action items that research institutions should be thinking about and doing today, including worst case scenario planning to be best positioned for what is yet to come. Hello and welcome. I'm your host, Marylana Helou. I'm a member in Epstein Becker Green's Healthcare and Life Sciences practice, and I am based out of our Boston office. From removing DE&I initiatives and principles in federal contracting and grants, attempting to slash the indirect cost rate paid to institutions on NIH grants, the suspension of foreign aid, and cancellation of federal funding already awarded to institutions for alleged noncompliance with federal civil rights laws, it is clear that the Trump administration is dramatically changing the landscape of federally funded research as we know it. What do research institutions need to know today, and what can they do to prepare for the future? If you like what you hear today, please subscribe to the show. Diagnosing Health Care is available wherever you get your podcasts. So joining our discussion today is Chi Fogler and Elizabeth McEvoy, both members of the firm and my colleagues in our Boston office. Liz handles a wide variety of enforcement and compliance matters for AMC clients and research institutes, particularly around federally funded and federally regulated research. She advises clients on how to avoid scrutiny of their funding relationships. And Emily works closely with research institutions on all aspects of clinical research enterprise, including human subjects protection, domestic and international collaborations as well. Emily and Liz, thanks for joining us.
Thanks so much, Marylana. It's great to be talking with you and Liz today. Thanks for having us.
Great. So lots to discuss today, but before we dive in, Liz, if you can, very briefly put in context for our listeners how academic, non-commercial, or industry-driven research is carried out currently in the United States.
Yeah, I think that's a great starting point, Marylana. So, a vast majority of the research that we're going to be talking about today is academic research. So what we mean by academic is, not provided for by a company, not for commercial purposes, but kind of, as we like to think of it, for the advancement of the science. So that research, generally speaking, is funded by our federal government. We have a variety of agencies at the federal level that support research across the spectrum of various degrees and various shapes and sizes. The Department of Health and Human Services, which we refer to as HHS, which houses National Institutes of Health, or NIH, is one of our largest, if not the largest funder, depending on how you slice it, of biomedical research. Billions and billions of dollars are given out. There's also a variety of other federal agencies, such as the Department of Defense, the Department of Education, Department of Energy, NASA, all of whom give out federal dollars to academic institutions, other institutions with an academic mission, hospitals, for the purpose of doing research. So when we talk about kind of research that's going on in the academic setting, there's really a very close tie to the federal government. And that close tie gives the federal government some direct relationship with the research institutes that hold the funds. So when an entity, take for example, an academic medical center, wants to do research, they have to apply. They have to fill out an application for that research. And that research funding will get evaluated and come to the institution. Those institutions, in addition to representing what they'll do for the science, are also asking for a fair amount of money. And when the agency actually awards those funds, they not only award money, but they also provide terms and conditions that must be followed in order to receive and use those funds. And those terms and conditions act like obligations that the grantees have to abide by. So the federal government has an interest and has historically, and we believe, as we'll talk about today, will continue to utilize that relationship to have some direct relationship with federal grantees and hold them to those obligations. In addition, there are other private foundations that support research, but really, as we're talking about here, the vast majority is done with support from our federal agencies.
Great. So it has been quite a challenging few months for our hospital, university, and other research institute clients. Keeping up with the daily, often hourly, and even overnight challenges and changes to the federal research funding landscape has been keeping everyone very busy. Can you explain to our listeners where things stand today with respect to the Trump administration's major executive orders and agency actions? I know there's a lot to cover, a lot of subtopics to cover, but perhaps we can start with the DE&I based initiatives and the two executive orders that instruct the executive agencies to end DE&I programs within the federal grants and contracts processes.
Yeah, and just picking up where we left off with federal agencies, the executive orders that we're going to be talking about here, those are orders to those agencies of how the executive branch wants those agencies to act. So the executive orders provide some insight and how the agencies will hand out and scrutinize and police those federal relationships. Two of those orders are DE and I based, and those two orders are called Ending Radical and Wasteful Government DEI Programs and Preferencing, which is 14151, and Ending Illegal Discrimination and Restoring Merit Based Opportunity, which is Executive Order 14173. They each have a similar or aligned purpose. 151 talks about ending DE&I and DEIA programs within the federal government. There's a preference in that executive order to ensure that there is no programs, policies, even preferences for DE and I within the federal government and the activities. Included in that is federal contractors and grantees. So as relevant to our researchers here who are relying on federal funds, 151, the first order, does call out that federal contractors are included within this order, which seeks to stop DE and I preference. Relatedly, in 173, which is the second DE&I order, that seeks to eliminate illegal DEI and DEIA kind of more broadly and prioritize the notion that people are merit-based and are going to be kind of awarded based on what they're capable of doing rather than these other categories. Specifically, this order 173 talks about and actually directs federal agencies to terminate what is called illegal and discriminatory policies, mandates, preferences, guidance around DEI and DEIA. And that is included not just, again, within the federal government, but in the contracts and grants they give out. So there are certain requirements and certain terms and conditions, as we've just talked about, which address DEI in a variety of agency terms and conditions and forums. And those now are being targeted, and this executive order is seeking to terminate those specifically. And there's also a call to action in 173, this second DE&I, which talks about enforcement and just flagging as relevant here two areas, two participants in federal programs who have been called out as needing heightened scrutiny are institutions of higher education. So we're talking about our academic institutions, also often homes for academic research, large academic research programs, and also large nonprofits. So those might include academic medical centers and hospitals. So both of those have been flagged as areas that may need heightened scrutiny over their DEI practices.
So, as many of our listeners likely know, the DE&I executive orders that you mentioned have faced legal challenges in the courts. Can you give our listeners an overview of where those legal challenges are today, and particularly the decision that was issued by the Fourth Circuit on March 14th?
Yes. So prior to March 14th, there had been some stability among the status. These executive orders had been challenged in court based on grounds of them being unconstitutional. And there had been a case brought in Maryland, in the Federal District Court of Maryland, challenging such orders. A federal judge out of Maryland put in place what we call a preliminary injunction. So there was an immediate pause to any actions relying on either of the two DE&I orders. Those include terminations, pauses of grants and contracts, as well as no new requirements that recipients of federal funds would have to certify they were also aligned with the policy and did not have what is called, quote, illegal DE&I. So that was a bit of it. That was a status quo that went on from the end of February But that order was appealed by the government. So the Fourth Circuit Court of Appeals weighed in on March 14th and actually lifted the preliminary injunction, agreeing with the government that there was not a basis to have the executive order enjoined or paused while the parties litigated the constitutionality. So, what that means in short is that those executive orders 151 and 173 are now valid, and those agencies that are subject to them can take actions consistent with them, including terminating funds, requiring new certifications. So it's a significant decision that came down from the Fourth Circuit.
Yes, definitely a significant decision. Can you talk to us about the executive orders regarding gender affirming care and gender ideology? How do those orders impact federally funded research?
Yeah, so similarly, we're talking about executive orders that are made directed towards the agencies themselves. These two orders are related, but again, kind of address different aspects of gender and sex based policy. The first talks about protecting children from chemical and surgical mutilation, and the second has to do with defending women from gender ideology extremism. So, the first one, chemical mutilation executive order, it focuses on terminating federal support. So, any federal funding for what the federal government has called in the order a so called transition. So, the physical transition of a child from one sex to the other. This, in broad strokes, is intended to defund, and this is language used in the order, to defund all federal programs and money that is going towards institutions who are performing or supporting these so-called transitions. So it is ensuring, in other words, that federal research institutions, federal education grants, money going out the door is not going towards what's being called chemical and surgical mutilation of children, directly impacting, of course, medical facilities that might have funding, but also think broadly about other institutions that might have direct lines of support to these particular procedures. The second executive order calls for an end to identity based concepts of gender, and sets a national policy of two non changeable sexes, male and female. This order, focusing on gender ideology, is also targeting all recipients of federal funds and calling them in action to align themselves with this order. So, specifically, this second gender ideology executive order directs the agencies not to use federal funds towards any grant or project that is promoting gender ideology. Now, there is no specification for what level of activity would promote gender ideology, unlike the other executive order, which seems more closely tied to the physical surgeries and other transformations. But this is a very broadly worded order that's targeting really any program that could be seen as promoting gender ideology. There's also a third executive order that I want to mention here, which is not specific to gender ideology or gender affirming care, but does fall into the gender based bucket, and it's received some attention recently. And that's the Keeping Men Out of Women's Sports executive order. This order was really drafted very kind of narrowly towards recipients of Title IX funds. So these are our educational institutions who are charged with providing women equal opportunity to participate in athletics. And as a byproduct of that, the executive order very explicitly says that men, biologically male individuals, are not allowed to participate in women's sports. And therefore, this executive order sets a policy of the United States to rescind all federal funds to educational programs subject to Title IX that deprive women and girls of fair athletic opportunities. So this has been construed to essentially take away funding from educational institutions that may not be aligning themselves with the policy of keeping biologically men out of women's sports. And there's a specific language in this order where it's asking the agencies, directing the agencies rather, that to review all the grants to educational programs and, where appropriate, in the discretion of those agencies, rescind funding to the programs that fail to comply with the policy underlying this order. This, in reality, has been used to target programs and educational institutions that have allowed historically transgender, or individuals who are not identifying with the sex they were born from participating in sports for their sex that they identify now. And that has been a really current topic that we see playing out.
Definitely, and we've seen, like you said, we've seen that play out already with pausing of millions of dollars in federal grants to certain universities. Is there pending litigation regarding this issue?
There is the two executive orders based on gender affirming care and gender ideology. Those were challenged in federal litigation in federal court. One of the cases is brought in Maryland District Court, and there was in March 4th a preliminary injunction issued that would nationwide apply to all the states and all the citizens of the United States, preliminarily enjoining the enforcement and reliance on these two executive orders while the parties litigated the underlying constitutionality. For the keeping men out of women's sports, there is active litigation, but there has not been a preliminary injunction imposed. Therefore, as you mentioned a moment ago, there has been some action to remove and rescind federal funding from educational institutions that are being viewed as not complying with that particular executive order.
So I want to shift gears now to talk about agency actions that have had a direct impact on research institutions' finances. But before we do that, Emily, anything you wanted to add?
Sure. I would just say that in addition to the DEI buckets and the gender ideology buckets that Liz mentioned and outlined some of the actions that the government's taken, I would add a third sort of bucket substantively to that list, and that's around the issue of foreign aid or foreign research, international research, if you will. Foreign aid actions that the government has taken, I'm sure many of our listeners are aware of cuts and impact on programs like USAID. And foreign aid itself is a little bit beyond the scope of what I know we're talking about today, but those types of actions do have impact on our research institution clients, academic medical centers, hospitals, and universities in a couple of ways that I just wanted to highlight. One is the fact of the matter is that in carrying out direct aid to foreign countries, many of our research institutions are involved in that aid. That aid is carried out through the work of research institutions, public-private partnerships, nonprofit institutions, and other modes of action, and in some cases directly through research grants. So there's an impact to our clients in that sense. In addition, as we've heard reported earlier this week, NIH may be considering cancellation or suspension of research grants that are funding work in particular countries. Reports earlier this week indicated that they may be looking at South Africa, and I think we can probably expect that other international research grants are also going to be in their sights. So just to add here that international research and international research collaborations are also at risk at this point in time.
Definitely something to keep our eye out on moving forward. So, Liz, the NIH's notice regarding indirect cost rates, can you give us a summary of that action and where things stand with the three related legal challenges?
Yes. So, as we talked about at the top of our podcast, NIH is one of the largest funders of scientific research in the United States. And so, as part of that process that comes down from the NIH when they hand out federal money through their notices of awards, they have some specific requirements for how the research is accounted for financially. There are two kinds of costs, just to set the stage for our listeners. There are what we call direct costs. Direct costs are the costs that are specifically attributable to a particular project, whether it's the staff or the equipment that's needed. And then there's another category of costs called indirect costs. And those are sometimes called facilities and administration costs. These costs really capture the research infrastructure, the construction, the utilities, the laboratory, in general, the support staff, and kind of any other costs that cannot be specifically attributed to a single project. So both components, both direct and indirect, make up the financial support that is coming from the federal government to the institution. So what happened recently to put indirect costs kind of on the map is that the NIH on a Friday evening at 6 p.m. announced a new notice where they were setting a uniform indirect cost rate for all institutions of higher education. So those are our colleges or universities. And this is a massive change because previously and for years, indirect costs were being analyzed and attributed based on specific negotiations from a grantee institution, whether it's a higher education institute or another one of the federal grant recipients looking for funding. There was a specific negotiation and allocation based on each institution and what their actual costs were. And it was an entire, very complex and comprehensive process that went back and forth. So these rates were negotiated on a per institution basis. That's the critical point here. So fast forward to the NIH order. NIH directed a uniform cost rate across the board for all institutes of higher education of 15%. Now, to put it in perspective, the kind of average reported indirect costs were 50 to 60%, with some institutions reporting indirect cost rates even higher, as high as 75%. So a 15% uniform rate not only changes the process, but it actually changes the value of the dollars going in each institution's pocket. This was obviously a very critical announcement that came, and it was going to take place immediately the following Monday to both existing awards that are consistently being drawn down upon, as well as future awards. So there was, as you mentioned, Marylana, immediate litigation. And there was actually 3 cases that were eventually consolidated in federal district court in Massachusetts. Those were filed on the following Monday, February 10th, and temporary restraining orders were put in place so that the agency action, the notice, didn't actually go into effect on that day as initially noticed. That case was heard through oral argument, and more recently, in the beginning of March, the court in the District of Massachusetts issued a nationwide preliminary injunction enjoining NIH from relying and implementing this 15% uniform indirect cost rate, while the parties, of course, are litigating the underlying issues which relate to constitutionality. And, of note, I think what took some solace for the research community, the court did find that the harm to research institutions was immediate, devastating, and irreparable, which she was in part required to find in order to issue the preliminary injunction. But it certainly was, I think, an injunction that made a great deal of difference on the ground, because it allowed the current set of recipients with NIH awards to continue to follow the process that had been in place beforehand. I do want to flag one nuance, one change around this litigation that is fairly significant, and that the court, when was looking at the preliminary injunction, the court wrote a very lengthy opinion. And one of the grounds that the court essentially found for deciding that an injunction was appropriate was that there was a likelihood that the parties challenging the constitutionality would succeed. And one of the grounds in which the court determined on a preliminary basis that the parties may succeed in showing this notice was unconstitutional is that the Department of Health and Human Services, HHS, the department that houses NIH, did not follow the prescribed notice and comment period, which is required of a variety of federal agencies and institutions. Specifically, the court pointed out that back in the 1971, I believe it was, the HHS agreed to follow these exact procedures, notice and comment, and has continued to follow them moving forward. So the court said, looking at the history here, there's a likelihood that the plaintiffs will be successful in showing that the failure to follow notice and comment for HHS in this instance invalidates the notice. And that was a big, important point that the court pointed out in deciding to impose a nationwide injunction. Well, just simultaneous to that decision, there was actually a change in HHS. So the initial kind of opting in of following notice and comment period was called the Richardson waiver. And on March 3rd, again, right around the same time that the District of Massachusetts was issuing an order on the preliminary injunction, HHS, that agency that had opted in, actually withdrew that waiver. So now, as it stands, HHS is not required moving forward to follow the same notice and comment procedures which were required under the Administrative Procedures Act. Again, applying broadly across a variety of federal agencies. So it is a constantly evolving legal landscape, but the takeaway here is that the federal court in Massachusetts has imposed a nationwide preliminary injunction, and the notice that NIH issued to set a uniform indirect cost rate is right now held in abeyance.
Great, thank you. That's really helpful overview and definitely a case that we are going to be monitoring. And it's not the last we'll hear about indirect costs or the Richardson waiver, I believe. So we mentioned this earlier that we've seen the administration cancel or pause millions of dollars in federal grants and contracts to universities for what the administration is saying is non-compliance with federal anti-discrimination laws. Emily and Liz, any thoughts on those actions?
I think they illustrate that the government is really proceeding to move here on as many fronts as it can to advance its goals. So this is just kind of, in my view, another front that the government is moving forward with to essentially reduce and take action with respect to research funds at these institutions. And so, the impact on research here is, I think, the total impact is yet to be seen. But certainly, this is another area where the government is looking ahead toward research grants and research funding, and trying to advance the goal of reducing the spend there in various ways.
Yeah, and I would just add, I think what these recent enforcement actions and kind of cancellations signal to us is that, you know, the agencies that are charged with handing out the money and making these arrangements with the institutions, they are going deep into their own policies and they're looking closely at their own terms and conditions and pulling out, these anti-discrimination laws that have been on the books for several years, and they're pulling out kind of agency objectives. And as Emily said, they're using them now as a front to scrutinize the actual grants that have been handed out, and in some cases suspend and terminate them. So it's, in some ways, this front is a sidestep around the executive orders, because allowing the agencies to look at the policies that are already in place and therefore cannot likely be enjoined under the same theories of litigation. And I think it just provides a lot of latitude for these agencies to cause a lot of chaos by acting, through these procedures that they are, on the books, they're allowed to implement and follow.
So, after this really great overview of sort of the state of matters for research institutions at the moment, let's talk about the practical implications for our clients. Emily, what can institutions do right now in light of these government actions?
Sure. Well, chaos is a great word to describe, I think, the way many of our clients and other institutions are feeling right now, looking at this landscape of various issues playing out, various fronts, and various litigations that are likely to take a fair amount of time to work through all of the legal issues and the other issues that Liz outlined. So I think many wonder, what can I do right now to address this situation? Are there concrete things I can do? And I think there are three things institutions should be looking to do immediately, if they're not doing already, to basically be prepared for kind of worst case scenario planning here. And those three things are really taking stock of what research at your institution is at risk, then trying to find ways to mitigate the financial impact or financial loss of the research that might be at risk, and then thinking about some strategies for how you might respond to specific cancellations or terminations on particular grants. So to start, I think in terms of assessing your risk and the magnitude of what might be at risk, it's pretty basic in terms of what I think we would recommend and what many institutions are already doing. And that is to really take stock of your federally funded research portfolio. As Liz mentioned, kind of among all the different funding sources that you may have at an institution, federal funding is likely to be significant. Take a look at that portfolio and identify all of the grants that could be at risk. What's the funding agency on those grants? How much time is left in the grant? Is the work almost complete or just at the beginning? What are the facilities and research personnel and other aspects of your institution that are supported by those grants and that rely on those grants that would be potentially in jeopardy if you were to lose those grants? So it's really a detailed stock here to try to assess what's at stake, what's at risk. We often get asked, how do you make that risk assessment? How do you pinpoint which grants are highest on the list of or high targets potentially for the administration? And I think there a productive approach is to really focus in on the topic of the grant. We know that the government is in part using particular keywords to search for in its funding databases and funding agencies and target projects based on whether or not they contain certain keywords, diversity, gender, etc. Many other words that the administration is using. And you could try to identify at-risk grants in that same way, but I think more productive is to focus on a specific topic of funded research and try to determine whether it's a topic that the government has indicated is maybe in its sights. Thinking about the buckets that Liz outlined, for example, of where the administrative actions have gone to date, and really putting those in the highest risk bucket and then kind of moving from there. I would say also in this assessment of risk, don't forget about grants where an institution is a subcontractor instead of the primary recipient of funds. So you may be supporting, or an institution may be supporting a grant that was actually received by another institution that another institution is managing. And the subcontracted institution is just managing a piece of that award. But those types of funding streams, if you're that subcontracted entity, could also be at risk depending on what that award is focused on. So it's really important to think about those as well. In terms of mitigating risk, I think there are a couple things that you can think about doing, or that an institution can think about doing. One is really at the level of specific grants, looking at what's the activity list for those grants? What does the project consist of? What remains to be done? Are there particular activities on your highest risk grants that you can move forward to complete perhaps more quickly than anticipated, and try to finish up the work? Are there things that can be moved around in your activity schedule along those lines? Another mitigation strategy might be more broad, looking at, as an institution, how you draw down funds from the government to pay yourself for the work done on those grants. As Liz mentioned, there are specific systems and rules and regulations around how funding is drawn down and the timing of such, et cetera. But our experience is that many institutions may incur a lot of cost and perform a lot of work, and then periodically go to draw down funds from the federal payment system to reimburse themselves. And there may be room to think about whether you can, at minimum, advance or hasten that reimbursement schedule, or even shift the way you plan out your activities so that you're drawing down expenses just in advance of paying them before you actually incur them, and then paying them out so you're not sitting on a lot of cash layouts while you wait for the government to reimburse you.
That's a really helpful checklist. And what about longer term action items? Any thoughts on those?
Sure. As I mentioned, one kind of immediate but kind of crossing over into longer term action is to think about what you will do if specific grants get canceled. Some institutions have received these cancellations already, but even if you haven't, there's things you can be doing to think about how you would respond if you do get such a notice. So one thing to be mindful of there is that there is an appeals process built into many of these cancellations, depending on the basis that the government is using to cancel the grants. As we alluded previously, often the actions are not tied to specific executive orders, but to more overall broad discretion that the government has to cancel or terminate funding for grants that it deems not to be scientific, or to no longer advance the priorities of the administration. So it's going to be really important as you think about these cancellation notices to identify what's the basis that the government is articulating for the termination or the cancellation. What appeal rights do you have? Think about when the grant was issued to you, because that will be important in terms of whether or not there may be challenges to the basis for termination that the government has articulated. Right now, under current regulations that govern grants and grant making, the government does have the ability to terminate grants for reasons such as the grant no longer advances the priorities of the administration. However, the regulatory language around that suggests that that particular basis for termination has to be referenced or included in the terms and conditions of your award if the government is going to rely on that basis. So there are things you can be doing now to look at when your grant was received. Does it come under those current regulations? Would there be a basis to push back if the government were to cancel an award on that basis? Are there ways to think about how you would justify the science behind the project that you're doing, or explain the science to the agency and make sure they understand what is actually happening in the work, what aims the work is carrying out, et cetera? Because we have seen, I think, in some cases that there may not be that full, thorough vetting of the science prior to these cancellation notices going out.
And one thing I just want to mention on that front, if I may, is as Emily said, there's a lot of nuances around what's actually in the terms and conditions. And we know that the government is, asking folks to kind of erase certain aspects maybe of their grants, talk about, why they're aligning themselves with the orders where they're, not imposing or adhering to DE and I, or not furthering gender ideology. And just a major caution when evaluating these individual requests and thinking about what you're going to represent back to the government. There is the potential False Claims Act where you could be, if you've already, represented that you're doing something to the government in receipt of federal funds, you want to be just very careful that you are not representing falsely something you did in any regard when it comes to what you held out as the basis for receiving those funds and what you have done. So, it's a really difficult landscape here when you're talking to the government about these so-called terms and conditions. But I just think it's important to flag that go at it with a lot of caution, because you do not want to, by attempting to comply with an order or directive from the agency, you don't want to walk yourself into a bigger problem with the government over grant scrutiny.
No, I agree 100%. And I think that same point applies in connection with potentially receiving federal funds for new grants down the road. One of the things that you have to certify, or that you are certifying when you draw down funds for a grant, is that you are complying with applicable federal laws and policies. And so if there are new grants that may be on the horizon, and again, this is sort of a forward thinking step, they may contain new terms and conditions that the government will include. And it's going to be really important to scrutinize and determine within an institution, can you comply with the terms that the government is attaching to the award, and how the government is likely to interpret those terms. That's going to be something institutions are going to have to look at very carefully, think about their risk tolerance in accepting federal funds going forward, with this kind of potential False Claims Act risk always in the background. So I think that's really important, both looking back to what you've already performed and how you report on it, and also thinking about what funding you might take down in the future as well. A couple of other things that I think institutions can be thinking about longer term is, again, because the impact of these actions is going to continue, presumably for quite some time, are there ways where you can shift as an institution some of your research portfolio to other funding sources, private funding, industry, other nonprofit sources, et cetera? That's going to be a very individualized decision and analysis depending on the type of institution and what the types of research are, but something to think about. In addition, also thinking about whether longer term your cost allocation model might be something that you can shift toward, away from certain indirect costs toward more direct costs. And that's something you're going to want to be very cautious about as well, and work with grant finance experts in determining and looking at your current allocation structure and what legitimately might be changed, if anything. But it's another potential tool in the arsenal to think about how you might try to shift some of the risk from indirect costs to a more direct cost-based model.
So to wrap up our conversation, I'll ask both of you, in this, really chaotic environment with the administration's actions still a moving target, on a daily basis. What is your advice to institutions? How do they avoid becoming overwhelmed with everything that's happening?
I think from my perspective, that fighting that feeling of overwhelmness and trying to figure out what concrete steps you can take is perhaps the best advice I can give. I think the worst thing an institution can be doing right now is to do nothing, to sort of wait and watch, for litigations to play out without taking some of the action steps we talked about. I don't think that we're going to be returning to business as usual in the federally funded research world. And so things are going to have to change. The way institutions handle some grants are going to have to change. The decisions that are made around carrying forward particular areas of research are no doubt going to be influenced and impacted by what's going on. So starting to do the assessment and kind of response planning at minimum right now, rather than waiting and seeing approach, I think is key.
Yeah, I agree. And we've already seen at least one court of appeals, reverse what I think many in the research community felt was the momentum towards declaring some of these orders unconstitutional. So we really know that anything, quite frankly, could happen with the future of the orders. And as Emily said, getting your house in order and being proactive about what your profile looks like is really critical. And I would just add on, think about focusing on documentation. A lot of times things have, our business as usual, certain people who are administering grants kind of know the ropes and know who to call and what to do. But I think where we see the government declaring in these executive orders a heightened call to action for the state's attorney general and for the various federal law enforcement agencies to enforce the orders, we know that use of federal funds is going to come under particular scrutiny. So whether it's for a false claim or it's a Title IX, a Title VII investigation, how you proceed about with those funds from the moment they come into your institution to who you give them to and why, all of that, it's just so critical to have documentation. And, I think as part of that, have your policies updated around the proper use of funds. And, as we mentioned briefly, there are a variety of other federal laws that are being used to deem in a particular institute non-compliant or ineligible. And those have nothing to do with research, but have to do with just general adherence to civil rights laws and Title IX and equal opportunity laws. So you can't solve all those problems at once, but try to at least get your policies up to date and kind of take stock of where you sit in the universe, and make sure that when questions are coming up, you're being thoughtful about how you answer them. And as we mentioned before, just not walking into a situation where you might be falsely representing what you are doing to the government, because I think that could be just an escalation of the concerns that no institution wants to add.
Great. Well, thank you, Emily and Liz, for taking the time to participate in today's timely and important discussion on the state of federally funded research. And thank you to all our listeners. If you like what you've heard today, please don't forget to subscribe. Diagnosing Health Care is available where you get your podcasts.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.